If you're selling a condo and you receive a contract, there is a section in that contract that covers assignability that you may look past. What's going on? My name is Anthony Johnson. I'm a real estate agent in Miami, and I'm also the creator of audio.com. And in this video, we're going to talk about assignability when it comes to the as-is contract in Florida. Now, when it comes to receiving an offer from a buyer, specifically if they're using the as-is purchase and sale agreement, there is going to be a section that addresses the assignability clause. Now, this clause is very important. There's three options that can be checked. One of the options allows a buyer to assign the contract to another party and can be completely released from the contract. Then there's another option where the buyer can assign the contract to another party, but they aren't released, meaning that they still are responsible for this contract. And then the other option is that they are not allowed to assign the contract. Now, why would a buyer assign the contract? If a buyer wants to assign a contract and just be completely released from it, then in a lot of cases, it's a buyer who is wholesaling, meaning that they saw this property, they think it's a great deal, they get it under contract, and they want to be able to sell that contract to an investor for a fee. So if I'm a wholesaler, I see that this is a great deal, there's a lot of upside with this deal, and I may want to get this under contract and shop this with one of my investors so that they can take control of the contract. Now, this is just my opinion. When I get contracts that has this check, I start asking a lot more questions, and I recommend that sellers pay a lot of attention to the contract, because if this is signed and you may not see it, and if your agent doesn't catch it, then you don't know what your buyer is really going to be doing. And for me, when I get these contracts, I'm thinking, is this going to close? So if a buyer is making an offer but they don't want to be held responsible for it, you want to make sure that somebody is not going to waste your time, because this person can try to shop your deal and they may not find an investor that wants to buy it and the deal won't go through. That's not to say that this happens a lot, but when it comes to my deals, I typically tell my clients to stay away from these. Worst case, you want to go with the second option where the buyer is able to assign it to another party, but they are still held responsible. They're not released. Now, in these cases, it's typically a buyer who is buying that also has a LLC or a trust. So they may be starting the process and the contract may include their name, but before you close, they may want to transfer the actual deed or the property to a LLC or a trust. There's nothing wrong with that at all. You just want to hold the buyer responsible to close that deal if they're going to go on a contract. But the last option is pretty self-explanatory. The buyer is held responsible for the contract and they are not able to assign it to another party. It's very important that you read your contracts. Contracts can be a little intimidating to read. Ask your agent questions if you have any, and if there's anything that is out of the scope of the agent, you may want to hire a real estate lawyer, because real estate agents are not able to act as a lawyer. We can fill in the forms and we can tell you what certain things mean, but we can't act as lawyers. We can lose our license for that. It's always helpful to have a lawyer on your team when it comes to contracts. Now, I hope that this video was valuable to you, and if it was, make sure that you like the video and subscribe to my channel. And if you have any questions or if you want to hear more about another topic, feel free to submit those in the comment section. I'll see you guys in the next video.